Welcome to the DC Bar Community's Law Student Podcast with your hosts,
Melody Al-Mansour, third-year student at Georgetown University Law Center.
Elena Hoffman, first-year student at the George Washington University Law School.
Renata Mitchell, second-year student at the George Washington University Law School.
And Alexis Bird, third-year student at UDC David A. Clark School of Law.
You're listening to Let's Brief It.
Welcome, everyone, and thank you for listening today to Let's Brief It, the podcast made for law students by law students. I'm Alexis Bird.
And I'm Renata Mitchell.
And today we're going to be talking a little bit about the jury selection process. Today our guest is Sellano Simmons. Sellano started his own firm right here in the District of Columbia, the law firm of Sellano Simmons, in 2011. His firm counsels companies, entrepreneurs, and small businesses. Prior to starting his own firm, Mr. Simmons worked as a trial associate at Dorsey & Whitney and was also associate counsel in the employee relations group at Target Corporation. In addition to practicing law, Mr. Simmons is a Rule 114 or Rule 114 qualified neutral trained in both facilitative and evaluative approaches. So thank you so much for being here with us today, Sellano.
I appreciate it. Thanks for having me, guys.
All right.
Can you talk a little bit about what it means to be a qualified neutral, and has being a neutral impacted the way you approach litigation and advocacy?
It has affected the way I approach advocacy and how I go about trials. Some people, or most people, believe in advocacy it's a zero-sum game. It's not. You always want to obviously get what's best for your client. A lot of my work primarily is in the criminal defense world. So in that case, it's always about what the client wants. We want the best plea offer. If we're going to trial, we want the not guilty verdict. So a lot of those skills are being used prior to going into the courtroom, that is talking to, in our case, the United States Assistant Attorneys or the Attorney Generals, the Assistant Attorney Generals here in Washington, D.C., and just attempting to get the best plea offers on the table. However, once we're on trial, we're out to win. To be a qualified neutral, it took, I think it was 40 hours, which is really just 1 week of training where you sit in the room, you're learning how to come to a consensus with people, how to give a little to get a little, how to walk away saying, I felt like we've given too much, but I also feel like they gave too much. And that's called settling, where no one's satisfied, but everyone's glad the case or the issue is resolved. And I think that's really helped my practice and helped me do what I do today.
So let's talk a little bit about the jury selection process then. I think it's the process of selecting people to serve on a jury for trial. And, usually the group of prospective jurors known as the jury pool, they're selected from the community randomly from a list of voter registrations, driver's license, state ID renewals, all sorts of information. Courts and attorneys then narrowed down the jury pool to 12 people in a process through voir dire, right? And
That's
then
correct.
They interview prospective jurors about their various backgrounds, their beliefs, just kind of see if they're able to actually sit and, make a selection or make a decision, a
Right.
fact-finding decision in that trial.
Yeah.
So can you talk a little bit about the purpose of the jury outside of that? Like, the word verdict, it comes from to speak the truth. So tell us a little bit about the jury as fact finders.
They're the most important part of the legal process, the criminal justice process. These men and women, other than the story you're going to tell, these men and women are everything. They're essential. I've practiced in two different jurisdictions, the state of Minnesota and also D.C. State of Minnesota, it's more liberal in the sense that you're able to engage your jurors. That is, I'm able to ask them, what books do you read? What do you watch on television? Where do you get your news from? What newspapers subscriptions do you have? Here in Washington, D.C., it's a little more controlled, where the judges do a lot of the questions, the voir dire. They're asking the potential jurors all the questions, and it's rare that you get a chance to really delve in, and that was new to me in my practice. I'm used to asking questions, engaging, learning their names, being able to talk a little bit with them. Here in D.C., it's really ran by the judges. Also, a major difference in D.C. that took some getting used to is even misdemeanor trials are bench trials. That is, they're held in front of the judge. In the state of Minnesota, all trials, whether they're misdemeanor trials or felony trials, are done with a jury, right? So there's a jury of 6 for misdemeanors in the state of Minnesota, and for felonies, there's a jury pool of 12 that you have, and you get to present your evidence. Here in Washington, D.C., misdemeanor trials, the maximum sentence for most cases, 180 days and or $1,000 fine, are held in front of a bench. And the Supreme Court has said, hey, we believe that's the least amount of time or least restrictive punishment. Therefore, it doesn't violate your right to a jury, and a bench or a judge can hear that case. It takes some getting used to. I think that, the jury is essential. I'd rather have or be able to present in front of a jury of our peers versus having one person decide the facts of the case. It's not to disparage our judges. They're great, but you always want the opportunity to tell your story to multiple people with diverse backgrounds and allow them to weigh in on what is, how do I put it, whether or not the government has met their burden.
So we talked earlier about the purpose of a trial as a search for truth. In real life practice, would you agree with that?
Not at all. It's not a search for truth. It is, I think, an attempt to hold the government to the highest burden, which is reasonable doubt. Is it a search to? It's not a search to know exactly what happened. A lot of time, jurors walk away and they have more questions they do answers. They have more critiques than they do anything else. And it's one where the jury pool is never fully satisfied. And that can look like, if they're going to return a verdict of not guilty, that means that the government did not satisfy them. They did not answer those questions enough. But no one's ever walked into a jury pool, I believe. I've never sat in a jury. But no one's ever walked away from a jury saying, oh, I believe I know what the truth is. Mm-hmm. They have said, I believe the government has not met their burden, or the government did meet their burden. And even when the government does meet their burden, a lot of times there's a question mark. They're unsure about everything, but they just believed at that moment, in talking with their peers, that they were able to unanimously come back with a verdict of guilt. Or there are a lot of times where they're saying, hey, we don't think the government has met their burden of proof, and in that case it's a not guilty. Doesn't mean you didn't do it, just means the government failed to prove beyond reasonable doubt that a crime was committed. But it is not a search for truth at all.
Okay. And do you think in the aftermath of the 2016 presidential election, has the so-called post-truth alternative facts era impacted jury practices?
The good thing is the jury practices are still sanitized. I think what it has done is, no matter where you are in the spectrum of beliefs, there's been an emboldenment where you're able to articulate very boldly, this is my stance, this is what I believe. And there's this question now about challenging people. If I were to walk in here and say, hey, I'm a white nationalist, well, that's my belief. You can't challenge me, right? There's more acceptance almost, or at least just a more willingness for everyone to be heard, no matter what spectrum you're on in terms of your beliefs, political views. There's just this almost, I would characterize it as an entitlement to say, I'm going to tell you my view, and I have no shame and to let you know. I do think, though, in a jury, the jurors collectively still do their job, whether their beliefs are for this person or that person, whether everything's fake news or real news. Something magically happens once those jurors are impaneled and they're sworn in. They really sit down and deliberate as the judge instructs them to do, as the law requires, and they really take their role serious, irrespective of their beliefs, irrespective of their politics. And I think that's important. I guess I should plug that it's so important that everyone register to vote, get their license, because these are the roles in which our municipalities are pulling from. These are the citizens that the municipalities are saying, hey, we need you to sit on these jury pools. And it's very important that we have a wide breadth of people. I see a lot of people sometimes, as they're being fordeered, they'll get up there and intentionally say stuff that they know is a trigger to get out of there,
Yeah.
have the judge or have one of the sides kick them out. And I cringe sometimes. I'm like, wow. I look at people and say, I didn't ask. If a judge asks you, can you be fair? I think you can be. Now, it's fine. You need to be honest. If you can't be, you can't be. But I really think a lot more people should be saying, yes, they can be fair, because all you're asked to do is suspend whatever belief you have and listen and judge later. And I think everyone can do that. And so I always want to admonish folks and say, we need you on juries, everyone. We need you to be able to suspend whatever belief you have and get on the jury, because it's so important to have a diverse background, because the facts matter, people's lives are at stake, and one person, a different person in the room, can change the whole outcome for someone's life.
And I think it's really important that diverse perspectives are seen, and I think the jury has historically been seen as a tool for effectively and fairly administering justice. So while everyone comes from different views and backgrounds, I think the jury being selected for jury service is a good way to contribute to society.
Absolutely. It's huge. It's huge.
And to have a difference in their lives, right?
Right.
So when you're going through the jury selection process, do you have a sense that jury's decisions are not driven by the facts?
I think everyone is human. You can't take that factor out, right? I think that individuals sometimes will get caught up in how you stand, what type of shoes you're wearing, how you interact or don't interact with your client, the cleanliness or lack thereof of your desk. I've had a juror comment on, it sounded like you had change in your pocket when you stood up, which is important. You need to know that. You need to be aware. So there's just these human factors that whether or not someone has change in their pocket or not doesn't matter with what is trying to be presented. But that human factor is a filter that you have to get through. That way, that can affect outcomes. So you as an advocate, and understand that we're talking to law students, you have to remember as an advocate, you have to do as little as possible, I wonder if I'm saying that right, to not become the distraction, not become the issue. Every trial lawyer thinks the case is about them. I walk into a courtroom, I say, it's all about me. And whether I win or lose, it was because of me. I don't care about the facts, right? You want to minimize any distraction that you can have, because it's not about you as the advocate. And once you do make it about you, then there's a problem. It's always about the client. It's always about the best story you can put out to the table for folks to accept or reject. And you don't ever want to be the problem. So that can be looking like, do I wear this bright purple suit versus a regular one? I don't know. That's
really get the jury's attention.
Right. That's for you to figure out. I'm not condemning anything. But what I do know is in the criminal defense world, you never want to be the main thing that the jurors are walking away discussing. It should be about your client. It should be about whether or not the government met its burden.
Do you think the public's perception of the American jury has changed over the past 4 to 6 years? And if so, what do you think might be contributing to that?
I think the public perception of the jury remains the same. There's a case, and forgive me, I don't know it now, but a case in the South where an African-American gentleman was tried multiple times. It went up to the Supreme Court. Was tried multiple times, and this prosecutor struck all African Americans multiple times. And this man was tried over 4 times, and each time, any person of color was struck. There was finally 2 people of color, I believe, and it could have been more, that were left on the jury, and that was because everyone ran out of strikes to get rid of them. So there are still issues, as historically there have been, with regards to juror pools, who's allowed to sit and judge the facts. That hasn't changed, where it's without fail I have clients look and say, this is a jury of my peers, and yeah, it is, even though they don't look like you, even though socioeconomics are different, geopolitical beliefs may be different too. It is a jury of peers, but historically, there are still issues that persist today that have throughout our history.
And are there any recommendations you can share for the voir dire process?
I think everything matters. When you're choosing your jury, I look at everything. While they're sitting there in the courtroom, I'm studying them. What are they reading? How interested are they? I look at, I try to look at if they're on their phone. What are they on? Are they on Twitter? Are they on Instagram? Are they on Snapchat? Like, what are they doing? It's important to listen. When someone gets up there and says, hey, I have a sick child, as a criminal defense attorney, I don't want someone in my jury who's not listening because they're concerned about their child. I think they need to be given the opportunity to go home and take care of whatever. I think it's important to observe everything, and they're doing the same thing of you. They're watching you look at them. They're watching you examine them. I look from head to toe, how they dress, what do they have on their wrists. Is there any type of clothing that? Because what I'm ultimately trying to do is I'm trying to get to a connection. If there's a book that I know they're reading, maybe I could reference that book in my closing argument, my opening argument. If there's a type of wristband they have that I might have, maybe I'm wearing that one day. You're always looking for a connection. Sometimes you don't find it, but it's always good to observe and also just listen, because the juror is going to tell you what they believe, what they feel, and it's may not always be articulated in words. And so you're just watching and observing. I think those are critical skills that we can never take for granted.
Okay. All right. Thank you. Well, given that we're a podcast created for law students, do you have any advice you can share to those who are interested in becoming trial attorneys?
Learn to get on your feet. I think criminal justice clinic's great. Learn to be a great writer. You don't have to be a great writer, a good writer. Learn to like people. You have to just have.
I think that's underestimated skill is underestimated in the legal profession.
People skills are huge. Empathy, understanding. I still get critiqued today. I had a client come out from the back in the court in DC courtrooms. Clients that are detained or held, they come from the back of the courtroom where there are jail cells behind the courtrooms. The judge had texted me, or one of the clerks had called me saying, hey, can you pick up this case? And I was in another courtroom, and I ran over. While I was running over to the courtroom, they were bringing this gentleman out from the back of the jail cell behind the court, and the judge called the case right there. We were on. I never got a chance to turn to him and say, hello, my name is. He never got the chance to say his name, vice versa, right? And then the marshals took him back, and then I had to run back to my courtroom. So later on that evening, I went to D.C. jail, met with him. And the guy says, I thought you were an a-hole. And I said, why? He said, because you never took the time to go back and introduce yourself to me before the judge called the case. So I had to explain to him what happened. He had no idea, right? And I said, I'm so sorry, sir. This is what happened. This is what occurred. I got a call to get in here immediately. I was in another matter. I had to run over here. As soon as I got here, they were bringing you out. I didn't get the opportunity. Yeah. And that one little thing, this just happened recently, but it taught me, man, you have to be cognizant of the small things. The small things are, look at me, look in my eyes. Do you care? These are human beings. Their life is on the line. They want to know, hey, can I trust you? We have a great relationship today. We're going to win the case we're in. Yes. It's a whole different type of case, so I can say that. But a great person. But it's the small things of that people skills are huge. And the small things matter in being a trial attorney, being a criminal defense attorney. But it's really, well, again, that connection to the jurors, the connection to your client. Mm-hmm. I think that's huge. So people have to just be open, be transparent, and be comfortable. You got to be comfortable in who you are. So that'd be my advice. Get comfortable being on your feet, and really learn people and learn how to engage folks, and always try to be working to make a connection.
Okay. Well, thank you so much for joining us today and to the DC Bar Association for hosting us.
Thank you.